So here's to you, Tommy Robinson. What am I going to talk about today? Well, Tommy Robinson, you may have seen, he appealed his sentence for his contempt conviction the other day and he got knocked back. So I thought this would be quite an interesting opportunity just to talk about the general principles. And I'd also like to clear up a few, I'll say misunderstandings, because the way some people are commenting about this whole affair, as always, I tend not to give my opinions, but I think there are a few things that need correcting. Also, this is quite interesting because although he's effectively appealing a prison sentence, a sentence of imprisonment technically, this was a civil appeal. So anyway, let's start at the very beginning, as Julie Andrew would say, because that's a very good place to start, excuse me. Okay, so what's this all about? Well, this all dates back to when a young lad was at school and he effectively got beaten up. But then, when this was all reported, lots of people at the school, some kids said, well, he started it and he'd been going around and he was the bully and he was the violent one and we were just defending ourselves. And Tommy Robinson picked up on all this, and it's fair to say he did lots of articles about what a dangerous young thug this kid was. However, this kid said it's not true, and he brought proceedings for defamation. And he was successful. Now, a lot of people have said, well, how's that trial fair? And what I'll do is I'll just link to the full judgment so you can read for yourselves what the evidence was, because people are saying, Tommy Robinson had 12 people coming along confirming his account. Well, it doesn't really matter how many witnesses you've got, it's the credibility of their evidence. And what happened here was, basically they were able to demonstrate and catch out kids by saying, well, you weren't at school on that particular day, or you weren't in that room, or you were not being in detention, or you were in detention. And it's fair to say the kids pretty much crumbled under cross-examination. And effectively they conceded. They hadn't even seen any of this. It was just pretty much just scandal, schoolyard, sort of gossip and innuendo, and kids basically trying to cover up for themselves by saying, but he started it, Governor. So that all collapsed, and the judge said, right, I am now satisfied that none of these allegations are true. He was in fact the person being bullied. That's defamatory, so Mr. Robinson, give him £100,000. Because the allegation was, the effect of the allegation was very severe. I mean, in the end, because this all went in the national press and people were hounding this kid, his family had to move house and is effectively living in hiding now. So the judge said, that's very serious, so have £100,000. But more importantly, he put an injunction in place saying Mr. Robinson must not repeat the defamatory allegations. So what happened subsequently? Well, Tommy Robinson, he basically kept repeating this, and he produced a, quote, documentary called Silenced, where he effectively tried to re-argue his case and just said, no, this is all the situation. Now, some people have picked up and said, why are the teachers prohibited from speaking about any of this? Well, as I explained in my video on NDAs generally, non-disclosure agreements, there are standard things in contracts with teachers saying they cannot discuss the personal and private things relating to their pupils. As I said before, you don't want the teachers sitting down the pub, passing down the ready rub, baggy trousers, all sort of going, oh, little Jimmy's a right tearaway, or little Susie wet herself in class. So teachers aren't allowed, in the same way that people in the medical profession aren't allowed to discuss what they learn about patients. Your sort of GP receptionist can't be down the pub saying, oh, Mr. Smith was in the other day, God, his hemorrhoids, I really feel for him. So that's the principle behind it. So there's nothing nefarious or sinister. But more importantly, NDAs don't count in court proceedings. So if Mr. Robinson thought these teachers could have assisted him, he could witness summons them. And that's what the court said on his, basically said, look, you had your go, you didn't call these people. If you believe you are wronged, or there's new evidence, or the court got it wrong, or something like that, well, appeal. But he wasn't. He didn't. So the situation is the injunction still stays there. And the documentary was in breach of that because it was repeating the allegations. So he was done for contempt. He was actually done for about 10 different contempts for every time he showed it. And actually the proceedings, he was up for about 6, and then, proceedings had started for contempt. And then he continued to do it about another 4, which is another reason the court sort of found that was an aggravating feature. So he was prosecuted for contempt of court. Now, again, I won't reiterate, because I've got loads of videos on this, so feel free to Google, about both the Tommy Robinson history of the trials, but also about these sort of issues generally. So he was done for contempt. Now, it's a rather strange thing, and people said, oh, how can it be done for criminal contempt when it's a civil trial? We have both civil and criminal contempts, but that relates to the seriousness of the contempt. It's not to do with the proceedings the contempt arose in. So you can be done for both civil and criminal contempt in relation to civil proceedings, but you can also be done for both civil and criminal contempt in relation to criminal proceedings. So to give an idea, in civil proceedings like this one, repeatedly breaching an injunction, that can cross the line into criminal contempt. I mean, if you're just sort of like late serving something, you know, you're in breach of a court order for disclosure or something like that, that's technically a contempt, but the court is more likely to deal with this as a civil contempt. I mean, it doesn't really matter because the penalties are the same. You know, they can do a fine or they can sentence you to imprisonment. I mean, like I say, technically it's not a prison sentence, it's a jail sentence, but in the modern era, there's sort of very little practical distinction. But it's the same in a criminal case. I mean, you know, if you sort of start standing up and kicking off in the public gallery and disrupt the trial, that could be deemed to be a criminal contempt. But again, if you just disobeyed a witness summons and they had to drag you to court, yes, you're in contempt, but that probably be dealt with as a civil contempt. So what can judges do? Well, like I say, they can fine you, or they can send you to imprisonment. But the thing with contempt is there is both a punitive element and a coercive element. And I'll come on to that because the court gave a big hint as to what Mr. Robinson needs to do if he wants to get out early. But the coercive element is, say you are just refusing to disclose something in a trial. I mean, this crops up a lot in family proceedings. You know, we want you to disclose your bank statements or your financial statements or reveal where you've hidden some property. I'm not going to do it. Okay, well, tell you what, you can go sit in the cells until you do decide to do it. And when you finally comply, that is called purging your contempt. So you go up and you say, I'm really sorry, I'm going to do it now. And the judge says, okay, I can let you out. And you can get a mixed sort of punitive and coercive sentence. And that's what happened here. I mean, basically the court said, we're giving you just shy of 18 months, 3 days shy of 18 months. 14 months of that is the punishment element. So you're doing that regardless. But 4 months of that is the coercive element. Which you can remedy by effectively, you know, not breaching the injunction anymore. And again, I'll come on to that. So what was the appeal? What were the grounds of appeal? It's all to do with his conditions in prison. Now, like I said, this was a civil appeal. So because he's out of time for any appeal, he needed the court's permission. And also, he wanted to allude to some new, quote, new evidence. So the court said, well, we need to look at whether this is really new or not. I mean, it's a bit like, you know, possibly what's going on with the Letby thing and the experts. You know, did they have an opportunity to do this the first time round? But in this particular case, he said, well, it's my situation in prison. So they got some reports from like psychiatrists and more stuff about the prison. What the court said is, well, look, we accept that the psychiatric report about what's happened since you have been sent to prison, you know, since your last, you know, then that is new evidence because by definition, it's only talking about what's happened recently. But all the stuff about what's happened generally, well, you know, that's stuff that could have been raised and indeed was raised in mitigation when you were being sentenced. Because the grounds of appeal effectively is the judge reduced the sentence to take into account that he accepted Tommy Robinson would have a hard time in prison, you know, because his lawyer said, look, he's going to have to go into segregation because there's a target on his back and because he's quite notorious. And being in segregation, which is very different, like I say, to being in solitary confinement, he's actually on a better regime than a lot of the prisoners, the general population in terms of, you know, his being able to leave the cell and do other activities. But they accept that he can only really speak to sort of prison staff or the chaplains or a few very other trusted people. So yeah, obviously it's an unpleasant experience. It's not like he can sort of be playing pool in general population because he's up for some you know, I'm just in for a bit of blagging. And it's, oh, okay, come play pool with us, you can be in our gang. But what they've knocked him back on is said, yeah, we accept it's not pleasant, but there's nothing here that wasn't alerted to the judge. You know, we'd already alerted to the judge, you're going to have a hard time. This is just confirming, yeah, you're finding it unpleasant, it's bad for your ADHD, it's bad for your PTSD, it's bad for your sort of mental health generally, but so what? You know, the judge took all that into account on sentencing. So they allowed the extension of time for the appeal, they allowed some of the evidence to come in, none of the stuff that was available, you know, for mitigation when he was actually sentenced. Remember, he pleaded guilty to this. So, you know, if he'd have thought there was anything in this, he could have done an appeal on his Article 10 rights. I find this is interfering and you're not allowing me an opportunity to put the record straight. If he'd wanted to, he could have tried to run that. And I'll leave the reason why he didn't run that as an exercise for the reader. But what I find very interesting, and if I can just bring this up, somebody more organised than me would have had this ready. In fact, I actually did have it ready and then I lost it again. But what has the court sort of said? Well, they have said the following, and I think this is the key passage. As I've said before, you can always read between the lines in judgments, but this is what the court said. And I'll put both the original defamation trial judgment below in the description, but I'll also put the judgment from the rejected appeal. But paragraph 103, they say this. It is appropriate to divide the sanction into punitive and coercive elements. The period of 4 months, less 3 days, is the punitive... 14 months, less 3 days, is the punitive element. I know I've already told you this, but this is the horse's mouth. The balance of 4 months is the coercive element. That means that it is open to the defendant to purge his contempt and seek the remittal of the 4 months of the order. In order to do that, he would need to demonstrate a commitment to comply with the injunction. That is likely to require, at the least, the removal of Silenced from his social media accounts and its removal, and the removal of the other publications that breach the injunction from other online providers, brackets, or at least taking all possible steps to secure their removal, close brackets. So there you go. So what they're saying is, and actually what they've said is, you can edit the documentary if you want, because, you know, most of it is, you know, you are perfectly entitled to say, you know, I am disappointed with the verdict. You know, I'm disappointed with the result. So that is implying that you think it's wrong, but without actually reiterating the allegations you were found to have made, you know, the defamatory allegations. So he could do that. So they say, basically, like, just take out the bits that are in the injunction and we'll let you out early. And again, my mystical thing, will he do it? Well, I think I think there's a good chance he will, that he'll suddenly decide that he will actually purge his contempt just to get out the 4 months early. And I think he'll say something like, I was cracking up, sorry guys, I still stand by everything I said, but, you know, they were torturing me, so therefore I did this under duress. I mean, that'd be his sort of get out of jail free card. But the thing to remember about this is, and I know loads of people are going to comment and say, oh, well, it's all rubbish, you know, this guy, he is the thug and he is the violent one and poor old Tommy's the innocent guy here. But this is just showing why the contempt was so serious. Because it was, you know, proven in court, and you can disagree with the verdict if you want, but I do say read the judgment, because I think anybody reading the judgment will say, oh, okay, maybe I can see why it was proved. Because like I say, Tommy Robinson's witnesses more or less concede that they'd made everything up. So that's always a bad thing. And it's not a defence just to say, well, I was repeating scandal and gossip. If it had said that in the trial, that might have reduced the damages a bit. If it had said, yeah, I now accept, actually, I was wrong, but I thought it was a legitimate matter of public interest or something like that, he might have got away with it. But once that was found, it's the repeating the allegations in breach of the injunction, you know, and not appealing. That's why the court are very sore with him. Because, I mean, let's just say somebody, you get an injunction, somebody's harassing you or trespassing on your land and you get an injunction against them. And they say, well, I don't agree. That's right, so I'm going to ignore the injunction. I'm going to continue to harass you because I don't think I am harassing you, or I'm going to continue to occupy your land because I think I have a legal right to be here. How would you seek for that to be enforced? Would you say, okay, fair enough, he disagrees with the result, so I'm just going to let him on with it? Or would you say, actually, no, I want, basically that's contempt of court, I want the police to come round and arrest him for harassing me or to remove them from my property? So, you know, that's, like I say, so, and the fact is, everybody commenting on this going, well, I still think the guy did it, and stuff, that is basically showing why he was held so long, and indeed why, I mean, who knows? Because theoretically, although, you know, he has been sentenced to this, what if he comes out and he still starts showing the film? Every time he does that, that's another breach of the injunction. It's another contempt of court. So theoretically, he could just be gate arrested, as we say. I mean, I suspect he will be gate arrested because there's still all that thing about not disclosing the PIN number for the phone. That's a parallel one, and if anything develops there, I might chat about that because that's got some general applicability. But like I say, I'm not particularly, I've just done this one because a lot of people have been asking about it and there seems to be a lot of misconceptions out there. So there you go. As always, hope you found that vaguely interesting, vaguely informative, vaguely accurate. And sorry I've been away for so long. I've just been completely snowed under with work, and apologies to anybody who's emailed me or contacted me or anything like that. And I know some people have actually WhatsApped me, but I don't use WhatsApp, so I apologise if I've never responded to your WhatsApps, but it's just something I don't know. But yeah, that's why I've been a bit AWOL. And I was hoping to get out somewhere nice for you, to film somewhere nice and sunny, but it's completely siling it down. It's typical. I've been busy all week, snowed under, sort of working 20-hour days, trying to get a couple of completions across the line and trying to get particulars drafted and defences drafted and all that sort of nonsense. And I'm just sort of staring out going, oh, it's so lovely and sunny out there. I should be on a cliff top somewhere, or, basically stealing some dogs. And I've been stuck inside. And of course, the first day that I'm off work, it turns into monsoon season.